I am pleased and so honored to be joined by our colleagues from across the city, from the Community Dispute Resolution Centers that oversee this fine work. We are joined by Katie Cole from the New York Center for Interpersonal Development, also by Patricia Haynes and her colleague John O'Cray from the Institute for Mediation and Conflict Resolution, our colleague Susan Petza from the Community Mediation Services, and also Carol Himes from the New York Peace Institute. We're happy to have you with us. Thank you for joining us.
Whole room for people to hug.
Hold on one second. That's a technical difficulty today. Just a few words on who is Synergia. Synergia is a multi-service agency located in Manhattan that has been supporting New Yorkers with disabilities and their families for more than 40 years. We offer a rich source of information and training tailored for parents, including parents whose primary language is not English or who they themselves have special training needs. We help them participate more effectively in their children's education and development, and we partner with professionals and policymakers to improve outcomes for all children with disabilities. Synergia, Spanish for Synergy, is one of New York City's 3 federally funded parent centers committed to serving people with disabilities and their families with an added focus on communities of color and the economically disadvantaged. Synergia creates innovative programs ranging from transitional housing for homeless families who have children with disabilities, parenting classes for adult parents with intellectual disabilities, and parenting and education advocacy training for parents of children with disabilities. So that's just a few words on us. As you'll see, we are, as I mentioned, we're one of the 3 federally funded parent centers, and we uplift each other's work. That would be advocates for children, as well as Include NYC. We're happy to have some of our colleagues from those organizations here this morning. A special welcome. But yes, so let's get into this, because right now we're finding ourselves going into the 2nd year of going back to school in the middle of a pandemic, and so many things that we haven't, so many unknown answers, I guess. And we kind of want to know, how do we go into the 2nd year better equipped? So that was the purpose in bringing this panel discussion together. So just before we start, we're going to do a quick presentation on the mediation process, what it is and how to, the ins and outs. And then after that, what we're going to do is have a panel discussion for all of your questions. I do want to say that if you have any questions, if they're case specific, for the sake of privacy, please feel free to reach out to us directly. You can reach out to myself or to the presenters that correspond to your borough. Also a note, this is not individual legal advice, and even though some of us are lawyers, it would be best if you consult directly with an attorney or with one of them before making decisions. So just that caveat. But yes, so without further ado, let's get started. So what is special education mediation? Special education mediation, it's a process that's enshrined in the IDEA, that's the Individual with Disabilities Education Act. And it's a part of where it's basically sets up special education law for parents of children with disabilities and school or district personnel to meet with a neutral person, a mediator in this case, to work out differences in a collaborative way. And it can be used in a number of settings. For today, it's for special education, and that can be used in early intervention or K through 12. So it's something that can be used for all of those ages. You'll also see it in terms of couples and resolutions between organizations and companies and divisions. So it's a very useful process. It's an ancient process. It's always being refined. And we are happy to be joined today by some leaders in the city of New York in this field. A mediator helps participants listen to each other's views and then assist parties to reach their own resolution or agreement. Both parties are involved in finding a workable solution, and I can't see my slide, so I'm moving the text here. The mediator does not make decisions for the parties. It is at no cost to parents as well. Who is the mediator? The mediator is not a judge, it's a neutral person. They've been trained to help parties reach an agreement about disputes, and it's a completely voluntary process in this case. The school must agree to mediation before it can take place, and you have to be willing as well. If you don't want to undergo a mediation process, you can always ask for an impartial hearing at any time. We will be sharing the slide deck with you in a follow-up email, and you'll have access to the hyperlinks. It'll give you access to more information and resources. What does a mediator do? So the mediator will identify areas of agreement and disagreement. They'll suggest possibilities to each side and bring them closer to agreement. They'll also facilitate drafting a mediation agreement that resolves the dispute if the parent and schools have come to an agreement. What are the qualifications of the mediator? Mediators are volunteers typically, and they have specialized training in conflict resolution from one of the New York State Community Dispute Resolution Centers. We are fortunate again to be joined by all today. We have the New York Peace Institute, which oversees mediation in Manhattan and Brooklyn. We also have Community Mediation Services that oversees Queens, the Institute for Mediation and Conflict Resolution in the Bronx, and also the New York Center for Interpersonal Development in Staten Island. A mediator, it's important to note, is not employed by the school district and does not have a professional or personal conflict of interest. Also, they receive 2 continuous professional trainings at least twice a year, and they've received training in special education laws and regulations from the New York State Education Department. I will say that does not necessarily make a mediator a specialist in special education. So that's important to note as well. When you go to a mediation session, the participants will typically include the parent, a student, if that's appropriate or possible, also a parent advocate and or an attorney. I have here EI, which stands for early intervention, the early intervention official, or the CPSE, which is the Committee on Preschool Special Education, or CSE, which is the Committee on Special Education, or often it's a District 75 representative. It'll also have school representatives, in some cases, principals, counselors, school psychologists, teachers, and also service providers. At the end of the mediation, what usually happens is the Bureau of Early Intervention, if it's an early intervention case, or the CPSC or CSE, they must immediately amend and revise the student's IFSP, which is the Individualized Family Service Plan, also the IEP, which is the Individualized Education Program, so that it's in conformity with the mediation agreement. The district representative will then arrange to have the agreement carried out. The agreement must be reached on any or all of the issues which were discussed. It may be reached on any and all. Sometimes it's a partial agreement and you just can't see eye to eye on every point. Sometimes you can get everything. So, any issue that is not settled, however, in the mediation session can be brought for further discussion with the early intervention and official, CPSE or CSE, or brought to an impartial hearing. If you have any questions at any time, please let us know. Feel free to ask any, but we'll keep going. Also about the agreement, it must be in writing. It's legally binding and required or compulsory. It includes specific actions with timelines and accountability. It'll say, for example, this needs to be completed by so-and-so by such and such date. And in the event this does not happen, this will happen. So this person will get involved, or this person will contact the parent. Number of things. It just depends on case-by-case basis. But that is built into the agreement, that accountability, which is so important. Also, the representative will arrange for the implementation, and agreements must be immediately implemented. It's not for renegotiation. One thing that's noteworthy, any discussion that takes place during mediation is confidential, and it cannot be used as evidence against either party, in this case, in an impartial hearing, and any appeal to the state review office or civil court proceeding. The parties to the mediation process may be required to sign a confidentiality pledge prior to the beginning of the process. And this is just to protect everybody, so everybody can have a conversation. Obviously, if there's something about abuse or neglect and something that obviously has to be reported, but other than that, it's not like you can have your mediation and then don't agree to something and then go to the impartial hearing, and then all of a sudden the school official says, well, mom said that, and the mediation process, so we know this already. That can't be used against you. So It's a good thing. It's built in there to protect you. How do you request a mediation? You must do so by completing the request for special education mediation form, which is hyperlinked in this presentation, which you'll receive later. And a parent will send it to their child's corresponding representative. The school will immediately forward the request to the local community dispute resolution center. In this case, one of these individuals or someone in their office would receive it, depending on where the school is situated. And they will assign a mediator who will arrange the meeting. The question is, when should you ask for a mediation? So you should ask for mediation after you disagree with the IEP's decision or recommendations. And that can be for a number of things. It can be for the need for more related services or different related services. It could be for classroom or school placement. If you're not happy with the placement, you think it should be less restrictive or more restrictive, you need more support. Also, compensatory services. Compensatory services are something that, as long as both parties agree to this can be a part of the mediation process and success. And the eligibility for services can be disputed, as well as the outcome of a manifestation determination review, which is typically a part of disciplinary procedures. When should you not ask for a mediation? So if the IEP hasn't addressed the issue, then they can address it by holding a meeting. That would be one part. Also, if it's not a timely, if it hasn't been brought to the attention timely, there's a statute of limitations which runs out, which is usually 2 years from the disputed IEP decision or discovery, parent discovery. Also, when a parent and the district are firmly opposed to compromise, you just realize you're not going to come to an agreement at all today or at all. That's when, you know, it might not be the process for you. And also, when all potential personnel have been involved and the issue has been explored without success, then that also might be another case. These lists are not exhaustive, so I mean, there are a number of situations, but in general speaking, what can a mediation not resolve? And this is, I italicize this specifically because it's not 100%, there are exceptions, but typically it's challenging to resolve the following issues. And that's when you're trying to assign a student to a particular teacher or a service provider, or when you're trying to have a school staff hired or fired, also assigning students to a specific school building that doesn't change or affect their placement, and the assignment of case management to other personnel. The benefits of mediation are numerous. It is less expensive. It is more collaborative. It is much quicker, which I believe, speaking with one of our colleagues here, it was 8 to 9 months is the average impartial hearing process. That's a whole school year. So, I mean, and it's not pleasant at all. I mean, not that mediation is displeasant or unpleasant, but it's a lot harder. Also, this is confidential. It offers an opportunity for relationship building and creative solutions. And most mediations result in agreements. I know, speaking with my colleague Carol, I believe it was somewhere in the high 80s or low 90th percentiles of success of mediation that result in agreements. But yes, and if you're not satisfied, you always have the impartial hearing process. So in summary, parties can discuss problems and solutions. It's a negotiation facilitated by an object or a neutral third party, and it's intended to result in an agreement between the parties. A mediator cannot force the parties to agree or impose a decision on them, and it's a promising alternative to the slower, more expensive formal impartial hearing process. So that's a quick presentation on all the ins and outs of mediation. I hope it's been concise and clear. You will receive a copy of this presentation, but right now I want to go ahead and give you the opportunity for everyone to have questions, to bring your questions to our panelists today. Also, I just wanted to ask our panelists a few questions as well, and please have an open dialogue amongst all of us. What are your tips, panelists, for how we should proceed trying to challenge issues from the past school year? Anybody want to take the first bite? You can unmute yourself. Go ahead.
Okay. Hello, everyone. My name is Patricia Haynes, and I work with IMCR in the Bronx. I think one of the first steps in possible mediation for something that may be happening or not happening during the COVID shutdown is to decide first as a family what you would like to see happen, what did not happen, and an outcome that works for you, your student, your family.
Thank you so much, Patricia.
You're welcome.
Any of you other panelists?
Yeah. JC, I'd say if someone has a concern, probably they might want to check in with you at first. You can provide legal advice and advocacy advice. That's something that we all can't do because we have to remain neutral. So I would say the first step is, I'm kind of just unsettled with what's going on. I don't know how it plays out. Can I please check in with these wonderful people at Synergia or some of your other colleagues that you mentioned are participating today and see what's what, and then use them as a really good resource and a sounding board, and then come to us if you think that you'd like some support in resolving the matter. I'd say the first step is talk to the school on your own. Most parents are really, really competent, but if it's not working, you tried and it's not working, you talk to the school, you talk to the teacher, it's just not going anywhere and you're worried, then you can come to, to Susan in Queens or to Patricia in the Bronx or Katie in Staten Island or us in Brooklyn or Manhattan and talk further about what your next steps might be. But I'd say use you all as a resource in the first instance.
Yes, and you can always reach out to Synergia and our colleagues at our other parent centers. A parent center is always a great place to start for information. A lot of the times we know who's working where in this field or in the field of question. And also we have vetted information. Sometimes it's easy to say, just Google it or just YouTube it and I'll find out everything I need to know. And then you find yourself overwhelmed with a number of things. It's they said this and they didn't say that, or this was good in 2008, but what does it mean today? So you can always count on your parent centers to have the most relevant and recent information to help you guide through situations that you might find yourself. Joan, please. John, were you going to say something? I can't hear you. Not hearing you, Joan. Sorry. Susan, are you able to?
Yes, I'm able to hear and I think you guys can hear me, right?
Yeah.
Something I just would like to add, if you're having trouble and you feel like you would like to start with an impartial hearing and you're going through with the case already, you can always have mediation while you're waiting, because parents are just sitting there waiting for a case. And like you said, from 8 to 9 months, if I'm correct, you can still have a mediation while you're waiting. So process is still going and you're not just waiting for it. So that's something you can also do.
Thank you. Yes, Katie.
I just wanted to add one thing. It's really important to know the parameters of the law, like Carol said, to get that information. But to be clear, that's not the only, that's part of the conversation, or that's part of the information you would need, because the conversation is much more, about the child, because no human being can be captured on a piece of paper, right? And so there can be some pertinent information that is coming up to somebody that is at the district level that can, you know, provide or hear something that's not showing up on the piece of paper, and ask them to talk more about that. And that's not because anybody is trying to hide facts. It's just that it's, you know, we all are so rushed to get information down, and the bare bones sometimes does not express that full component of what's going on and what the child's needs are and what have been used in the past.
Mm. Joan, are you able to connect?
I apologize. I lost connection. I couldn't hear you. I could see everyone, but I couldn't hear anyone. So it was my technology. Sorry about that.
No worries. What were you going to share with us?
Oh, I was just trying to say I couldn't hear. I couldn't hear what was. Yeah, I didn't hear what was going on. So continue.
Sure. So we have a question here. I know some families that tried mediation, and at the end of the day, they had to go to an impartial hearing because mediation didn't make any difference. How can the mediation process be improved? And also, how can parents prepare themselves to have a better outcome from mediation? That's a great question. Thank you so much.
Hello, JC.
Yes, Patricia.
Thank you. One way that parents can equip themselves well, and I don't know if some parents have already tried this, is to have reports, evaluations, any information on this child, student that maybe the school or the committee, the various committees may not have. That is essential, as well as the parent reporting on what their experience is in the home with their child, because parents are experts on their child and their children, especially one-on-one. And there may be information that is shared from the parent that might be helpful to whichever committee or the school to help serve that child well.
That's a great point. Thank you so much, Patricia, because that's one thing we always say at Synergia is that, you know, no matter who has whatever degree and whatever, at the end of the day, you have all the history behind that child's experiences, and you know the triggers that that child might have, the struggles that that child might have, and the strengths that that child might have. And maybe it's not mentioned explicitly in a conversation, but you know, that has a huge implication if you share it, because like, oh, that's another way we can create a solution. So yeah, I really appreciate you saying that. And especially like those documents and sharing those experiences that maybe, you know, it's not an academic record or something that has been, you know, listed or evaluated or observed in, you know, that 1 hour observation session that they've gotten or something that they've seen. So thank you for that.
JC, I echo what Pat said. It's very important to have a current IEP. Some parents, they don't have a current IEP, and they're sort of like going off the top of their head of what they think is in the IEP. So it's very important to have a current IEP so the mediator and everyone at the table can go over it in writing right then and there.
The current IEP, yes, especially when you're trying to obtain other services or challenge services. And I also want to say, you know, that's a good opportunity to, you know, you don't agree with the district's evaluations, that you also have the right as a parent to obtain independent evaluations. I believe that can be obtained through mediation. Panelists, is that right? And at the district's expense.
Yes.
Let's see. We have a comment here from one of our advocates. You said that matters discussed in the mediation cannot be used outside. But if you are filing an impartial hearing for an issue that occurred the same school year as the mediation, will a parent have trouble trying to file an impartial hearing for an issue that is different than what was discussed during the mediation? I am worried that the mediation process can stunt what happens during an impartial hearing because of the agreement regarding privacy of the mediation process. It's a really great question. Panelists, do you have some ideas on that?
Hello, it's Patricia again. Coming from a non-legal background, any information that the parent or the district or the any of the committees share during mediation is open to be shared during the impartial hearing. It is not open to be shared with agencies, groups that are non-participant in this student's situation.
Sorry, can you repeat that, Patricia? Because I think I misunderstood what you were saying. So can you just repeat what you said, please?
Yes, I started out saying that in a non-legal context, I'm giving some information. I'm not an attorney and I'm not giving legal information. What I am saying is that what is shared during mediation can be shared it cannot be shared by, okay. Thank you. Why don't, I'm sorry, Carol. Yes, why don't you make the comment?
So in mediation, and you all help me, tell me if you agree, but in mediation, what's said in mediation, in that context, under IDEA, stays in mediation with the exception of child abuse, which can be shared because there's obviously an exception when we have a concern about safety to a child. So mediation basically can't be used as discovery for an impartial. Otherwise, why would someone go to mediation, right? And so what is said in mediation has to stay. What I think, Patricia, you're thinking about is if there's a mediation agreement, it obviously has to be shared because it has to be actualized, right? It has to be, the IEP has to be updated, all of that, but the discussions have to stay. That means if parent shares something, it can't go outside. If the school shares something, it can't go outside. Okay, so that's really foundational to supporting honest conversation in mediation. Okay.
Thank you, Carol. Can you speak about the documents that are shared during mediation?
Anything that's said or shared in mediation has to stay in mediation, with the exception of concerns about child abuse.
So Carol, this is Joan O'Cray. So Carol, what I hear you saying is, I think the question was that mediation can stunt the impartial hearing because everything should be stayed in mediation.
But look, first of all, if there's a mediation, we all know, all of us, like you guys tell me mediation centers, start to finish, we're done in a couple weeks to a month tops, right? If you file simultaneously a mediation and for an impartial, then impartials, you're not going to hear from impartial hearing office for what, 8-9 months, I think is right. Is that right? I think
Yes.
What I'm hearing, although I could be wrong. So look, you have the mediation. You can ask for mediation at the same time you ask for an impartial. What's resolved in mediation, the mediator will write up. And if there's simultaneously an impartial filed, what a mediator would do, what I would do in a mediation is, let's say there are 3 issues that want to be discussed in mediation. Let's say resolving number 1 and number 2. I would write, this is number 1, what happened in number 2. And I would write that number 3 is unresolved and then would go to the impartial. So that's really what would happen. And we've done that. I'm sure you all, in the other centers have done that as well. Yeah. So I'm not sure how that would hold back an impartial. By the way, by law, under IDEA, mediation can't be used to deny or delay an impartial, by law. So I think there is some confusion around that topic to me, but let my colleagues share, see if you all agree.
JC, can we have the question repeated because it's a little two-step
Sure.
question, okay?
Yeah. So you said that matters discussed in the mediation cannot be used outside, but if you are filing for an impartial hearing for an issue that occurred the same school year as the mediation, will a parent have trouble trying to file an impartial hearing for an issue that is different than what was discussed during the mediation?
No, because you're talking about two separate issues. You're talking about an issue that took place in the mediation, and you're talking about a different issue that was not part of the mediation. We're basically talking about what happens in mediation. So if the person had a different issue in the school year, that would be separate of the first issue.
Gotcha. Okay, that's clearer. That's clear. Okay. So
Right.
if it's two separate issues, then absolutely, it shouldn't delay or be a difficulty there. But the person's concern was that they were worried that the mediation process might be a stunt in what happens during an impartial, might stunt what happens during an impartial hearing regarding the privacy around that.
Right,
Okay.
but keep in mind, you're talking about two separate issues.
Mhm.
In
Okay.
other words, the party is not going in and say, well, I had a mediation and it was about A, and now I want to bring in another part of the mediation. I want to bring in a separate issue, B, that has nothing to do with A.
Okay.
You see? So
Yeah.
you're talking about two different animals.
Okay. No, that's great. There is a question here. Can the panelists discuss in detail the misconception about what we can and cannot mediate? For example, compensatory services. I've been in meetings where I've been told by DOE personnel that we cannot mediate compensatory services because it has a dollar value associated.
That's a good one because a lot of the services have dollar values. So it's that needs clarification, I think.
Mm. Any other thoughts?
So here's what we have mediated compensatory services, and if it's to provide services to make up for services that haven't been provided already, and it's for a DOE provider, then that can be mediated in mediation. I think what is being conflated is if a parent, for example, let's say the student had speech on their IEP already, 2 times 30, wasn't delivered last year. Parent said, I don't want to wait for that anymore. I'm going to hire this person. I'm going to pay him or her, and I want the DOE to pay us back. The DOE will not, we can't mediate the repayment of money that's already been paid. That's actually not because of what the DOE provides. That's actually because of a New York City comptroller's guideline. And so that, I think what's happening and what the question is. But if it's a service to be made up for a service that was not delivered, that can be mediated. It's the back payment, we can't mediate that.
Okay, so I've participated as an interpreter in mediations and an impartial hearing. So I've seen compensatory services being in both contexts. So what I'm understanding is that, for example, if a parent they couldn't get their child or the DOE to give them the permission or the RSP, is it? No, RSA. RSA for going to a private school, and they fight it in something, they can't negotiate that in mediation, So like, I sent my kid anyway, and now I just want the school district to pay for it. That's something that cannot be done through mediation. Okay. Yeah, that's a little confusing.
Yeah, it's sort of like you have to have the approval of the system that they're willing to pay. If you go outside of that without their approval, you're on your own.
Mhm.
Because they can say, well, you didn't ask us. You didn't give us a chance to give you an answer, because the services that you're seeking, we have them. It's just a matter of finding the location in the school that can provide the service.
Mm-hmm. Okay. Let's see. One of the questions that was asked was, is a lawyer needed to do mediation?
Hello, it's Patricia again. A lawyer is not needed to pursue mediation, and it is helpful if the parent or whoever is representing the student involved, it is helpful if they know what the laws are and what favors their child under the circumstances.
Would you have better success with a lawyer or a parent advocate necessarily? Or is that? Katie, go ahead.
Oh, go ahead, Patricia. Oh,
Katie,
go.
you go ahead. Thank you.
I was just going to say, you know, it depends on how your advocate, whether it's an attorney or a parent advocate, is advocating. You know, it's there's human nature going to be involved in this informal process. If you start out like a, you know, a fierce, aggressive kind of thing, it's shut. People can't hear even if you're saying something that would be helpful. Do you know? So it depends on how you're advocating. If you're advocating to win, then that's going to be, it could be problematic. I'm not saying it won't work. I'm just saying that it's better suited to have an advocacy approach that's really talking about the parents and the child's needs. I have had situations both ways, and the difference is stark. Doesn't mean the outcome is necessarily stark, but if you think about it, you're talking about an ongoing relationship, right? Even the decision maker is going to be an ongoing relationship. And if that district representative is talking to all their colleagues and they never do it again, they're going to own, you know, people, it's just a way to try to stay emotionally safe when you're in those things. And anytime anybody's attacked, they're going to, you know, be defensive. That's not to say that you're a pushover. That's not at all it. It's just saying, okay, let's try to find some ways to make this work, because obviously this is what the child needs. And, you know, let's brainstorm about some possibilities that are not directly stated in the law, because as everyone knows, the law, what the law says depends. Unless it, you know, it says it, you know, like if I run a stoplight, that's not up for a lot of discussion. But, you know, some of the ways that things are interpreted and could be tried, and there's always temporary things that you could try just to see.
I have a question. Can each of the panelists share with the audience the trends and about issues mediated in all systems, such as early intervention, CPSC, CSE, that you're seeing in your mediation centers right now? Go ahead, Susan.
Early intervention, we see a lot of requests for services. They don't understand usually. And there's a lot of misconception about early intervention. There's about percentage, and parents never understand that. They always come to mediation really not understanding. And that goes back again for our intake. When we do intake, we always invite them. It's not that they have to, but they should have, or it's recommended to have an advocate, because there's a lot of little parts of the law that is very difficult for parents to understand, and they come with that misconception already. So a lot of part of the mediation process, part of it is explaining that percentage and why is my child not getting the service? She cannot even say a word and she's like 18 months old. And then there's a lot of like, oh, she should be saying this amount of words. So a lot of the early intervention is explaining that part. I see a lot of that. And obviously then the service, and they don't like the service coordinator, they would like to change it. So there are a lot of that goes a lot with early intervention. Now, special ed is more request for services, transportation. We had transportation services, language. Sometimes like the child has English is not their first language. So that's a lot of the service, especially in Queens, because they have so many languages in Queens alone. So that's a lot of what we get in Queens. That I could speak for Queens, that's all we get for Queens.
No, thank you. Thank you for that. Katie, what do you see in Staten Island?
We see a lot. What we've been seeing quite a bit is services that have not been provided because of the inability to be effective via a video. And the other thing that I am starting to see that's cropping up is, when you have children that are on the spectrum, there are really people that are asking for specifically trained personnel to work with their child and to work not just with the child, but with the teachers that are serving that child, because they feel very strongly about the structure of that instruction is really very necessary in some cases. To really be able to help that child behave in such a way that they can be successful academically.
Patricia, Joan, any trends that you're noticing in the Bronx?
Well, always there is disagreement about in early intervention about whether the child qualifies or not. In special education, I've seen cases where and especially during COVID, where it's been difficult to link a provider with a student who has an IEP that states certain services should be garnered. And I would not be surprised if we see more of those types of cases as the school term picks up. Service provision can always be disagreed about. And there are certain ways that in each service, occupational therapy, physical therapy, speech and language therapy, there are certain evaluative tools that can be used to look at how the student is coming along.
Carol, any trends that you're noticing in Manhattan and Brooklyn?
Echo what my colleagues are saying across the city. I totally, we're seeing all of that. I do want to say that as children start returning back to school, I think it's fair to say that a number have experienced very significant trauma through the last year or so. And I think it's likely that there will be behaviors resulting from some of that, especially with kids with IEPs. And I think it would be really effective and important to have discussions around supporting those children and their behaviors especially. And I'd like to just say that that's something that I expect. I'm not seeing it yet, but I expect that we are seeing what everyone else is seeing as well. Now, I think it's going to shift in the fall.
Yeah, there's long-term effects from all of this. Absolutely. I'm glad that you mentioned behavior, because one of the questions that just came up was, can ABA services be discussed in mediation? I see consensus on your faces. How would you go about doing that? Is that something you ask for a functional behavior assessment, and then you're not satisfied with the results or the recommendations of the school, and then you would request for ABA? Is that how that would probably play out?
Carol, how's that play out in the Peace Institute? I can tell you how it's played out here in Staten Island.
Go ahead, why don't you go first, and then I'll, if you want, Katie, or I'll answer. I'm happy to answer that, but if you want to go first, go ahead.
No, go ahead. Go ahead. That way they don't have to hear my Southern accent again.
I love your Southern accent. I've loved it for years, Katie. Don't be silly. Listen to you all day long. So I think of this in two pieces. For EI, the ABA is something that can be discussed kind of straight up. And that's absolutely something that can be discussed in an early intervention mediation. So let's put that in one place. For special ed, the standard, you all know this better than I, is a free appropriate public education. And then you can have a discussion about what's appropriate, and is ABA appropriate? And then how is it delivered in a public school, or does it need to be discussed and delivered in a non-public school? And if the public schools are not delivering it, and that's a student that really needs that because they're on the spectrum and they really benefit from that, and they've over time maybe had a history of benefiting from it, then you could talk about a CBST deferral, a deferral to the central base support team to a non-public school. But that's, I mean, we all know that the standard is first, the question is, can the Department of Education deliver a service that's appropriate in their own system before it would ever go to a non-public? So that's kind of, I don't want to put something out there that's hard to deliver. It is, but that's what the standard is. Is it appropriate? And then you'd have that discussion. So think of it in two pieces: early intervention, kind of more direct, and special ed, then how does FAPE deliver free appropriate public education? And that's a discussion we can absolutely host in mediation. Katie, did that work for you? Now I'm going to hear your Southern accent.
Yeah, yes, because I've had several mediations around this, and so I just want to say that this just happens to be, you know, the mediations that I have been involved in, because the question has been, well, the IEP team say they can't recommend that, and it has been literally reiterated that it is the IEP team to decide what services are needed for that child. Okay, whatever those services are, they need to be recommended by the IEP. And if it is recommended by the IEP team, that then it should be so noted in the IEP. Now, let me say something. That is not a universal thing that I hear in mediations, because I don't have just one person that is speaking for the district. So I just want to be clear that, you know, I hear a lot of things that some of the district people say that I'm going, we just had a mediation about this, and that's not what the other person said. So you know, I'm just telling you what my experience has been. My observations have been, you know. So, and for me as a mediator, I don't, sometimes things are inconsistent, and I'm not really sure, you know, what the parameters are for the decision making that could come up with different reflections from whoever's representing the district.
That inside the black box perspective.
Okay, Katie, this is Joan. I can agree with you. Sometimes I come across that too, where one part of the district will say one thing and another part, but I usually say to them, could you show me in writing where that is stated? You know, is it a statute? Is it a rule? Is it a law? I like to see it in writing, because one person's interpretation is different from another person's interpretation. But if you see it in writing and go over with them, then they say, oh, no, I didn't mean that.
Mm.
A-
I'm glad.
And
you
Joan,
mentioned-
that's,
Go ahead,
go ahead.
please.
I was just going to say, Joan, that's a very good idea. And as a mediator, if she's signing her name to it as a representative for the school district, that right there is going to take, but you're right about, and I don't know how to move back and have someone that can make the final decision up here and not just the individuals at this level, could just be real explicit about what that is and just send to us so that it's not in question about how the interpretation is going.
I'm glad you
That's a very good point, Joan.
I'm glad you all mentioned this, because this is actually one of the questions that came up in the Q&A, is that can the mediator correct the DOE if they incorrectly cite procedure or law during a mediation? Yes, Susan.
We have to always remember that mediators are neutral, impartial. We do not, and that's why we always say, we recommend bring an advocate. We recommend, but what can the mediator do? The mediator can ask the right question, like I think Joan just said now, or Katie. Ask the question, could you please show me where it's at? Or could you please read it out loud? Or where does that stay? Because a mediator always say that we have to play the dummy. We don't know anything. We always ask questions because we don't know anything. We're not supposed to, right? So we're always asking questions. And that's what I mean with that. We're always asking questions to come into that answer or verify, or if we see something is different or odd, not that we know the law or we be citing the law, but we would ask the question to clarify that. Or please, could you please clarify it? Could you please read it? Where are you getting that from exactly? Where is that cited? Is that a state law? Is that a statute? What exactly are you coming from? And could you explain that? And how is the DOE part of that? Or what is your role in that? How does that play out? Always asking questions to clarify. So that's how can a mediator interject in that process.
Right.
And
And
go ahead.
Susan, I'd like to add to that. It helps not only educate the district or whoever is saying it, but it helps educate the mediator. It helps educate the parents, because I had a situation where the district was saying, well, I don't know if we can do that. And I said, is there any of your colleagues in your office that we can call and find out if this is appropriate or whatever? And she got on the phone and she called, and the answer was a yes. So it's like when you're in doubt, ask the question.
Mhm.
I
By
just
the way,
wanted to
beautiful
highlight.
question,
Yeah.
Joanne, sorry. Beautiful
Yeah.
question to ask, because we get a lot of that. We can't do that.
Right.
I'm sorry. We can. And you're thinking
Yeah.
that this is mediation for mediation. You're supposed to discuss that. So that's a really nice question you asked there.
And what I found out is it can be problematic for me is sometimes there are people that are representing the district that are so defensive that it's like taken as a personal insult. So, I'm a Mississippi hayseed. I just know how to ask a question straight out, right? So I'm having to learn how to ask that in such a way that it really is curious about, if there's some disagreement here, how can we, what do you think is some ways that we can find out that information and have that information come into the mediation without anybody feeling, defensive?
Joan, I think you were going to say something, and then Carol.
No,
Oh,
Carol,
okay. Carol, please.
go ahead, Carol.
Thanks. Well, I agree with everything that Joan and Susan are saying, and I think really it's spot on. Wanted to add also that as mediators, we do intake before a case ever begins, and we talk with both the parent and the Department of Education. And if the parent is thinking about, I think what I'm thinking about is I'd like to explore this possibility, and a Department of Education person says, I can't do that, we might explore that in the intake and sort that through before we ever get into the mediation session. So that's another place that as mediators, we sometimes can be helpful. And I often say, if you can't do it and that's what the request is about, then maybe there isn't a mediation, because why are you going to be there, right? So we all, and it's not just us, across the city, we all do intake with both parties. And so that's a place where that comes up sometimes as well.
But you want to stress mediation is an educational process also for everyone involved. So we all learn as we go.
Together.
And we learn from each other.
One of the questions we just got was, so the parent can ask the mediator the other side to clarify inconsistent ideas, and how can parents encourage this? Thank you for that.
Could you repeat that, JC?
Sure. So the parent can ask the mediator on the other side to clarify inconsistent ideas. And if not, how can parents encourage this?
What do you mean other side?
I believe they mean the district.
Oh, okay.
The district rep, yeah.
Okay, all right. Yes, of course, ask the question, you know. Even the parent can ask the question, you know, to the district. I encourage that the parents have a dialogue with the district. Very, very important that the district talks with the parent talks with the district. And then you'll find a lot of clarification, a lot of understanding taking place. And that improves the decision-making on the district when they know more about the parents and the student or the child.
Yes, Susan, please.
So it's important to remember that mediation is a process for a conversation between school and parents. So how can parents, we are just there to facilitate, pretty much. It would be wonderful if they both parties could just sit there and have a regular conversation, and we just intervene in the points. And this is basically what the mediator is there for: clarify things, make sure things are on place, and everybody understands it. It's almost pretty much for people to understand each other, because most of the times that's why we're in mediation, because people are not understanding each other. So it's majorly, that's what the mediator is there for, is always to remember that mediation is an open, place for you to talk about feelings, for you to talk about anything that you feel that is. I always hear parents say, but can I say that? Oh, but could I ask that? You can ask. There's always, like a mediator is asking questions to clarify. Parents should be, feel comfortable. And that's what you should trust the process, is to feel comfortable to ask questions that you feel that are important to you, because that's the place to do it, pretty much, because you have a neutral party there.
Mm-hmm.
And that's something that you can stress in your introduction for both the district and the parents and the advocates and all that involved. We want to hear from everyone. We want to give everyone a chance to speak and ask questions.
Do you have any specific recommendations, and this is for all of you, for parents that English isn't their native language, on how to approach mediation, or something that they can do to help their success in the process be better? Because many times it's unfamiliarity with the process, or intimidation of other officials, or too many people in the room at the table. And that's on top of the language barrier, or that lack of knowledge. Do you have any tips for parents in that situation? Yes, Susan, please.
We get a lot of Spanish cases. I can speak Spanish and Portuguese. That's all I can do. But I always tell parents, like, when I have the intake, I always say that the school is supposed to give you a translator for the process, the whole process of the mediation process. It's also comfortable to know the language. That helps a lot, at least because usually the first language, Katie was saying her accent is weird. Mine is the weirdest, because I was brought up in 2 different languages at home. So I understand the importance of having that first language being the language that you feel more comfortable in. And sometimes they feel they can't express it. So we try to have mediation with the translation and the whole process with the translation to help that parent feel comfortable. So when they're coming in, they feel like they're saying a word, they're not understood, and then the translation. So I think translation is crucial too, to make sure that you have a translator in the process that's doing the correct translation of everything. because in the language that it's English to English is already sometimes confusing. It could be even more confusing to another language. So I'd say that translation, and please correct me on the other CDRCs if I'm incorrect, but I think that the translation is a major role when we're having parents that do not speak English as a first language. So answering the question is making sure that you have an accurate translation of the whole process from intake to agreement, and making sure that that's, literally the same, try at least to the dot, so that people understand.
Yes, Joan.
I agree with Susan. I do a lot of Spanish cases and I don't speak Spanish, but over the years, I have gained knowledge through inference. In other words, body language, the tone, and working with a translator, you want to tell the translator that we're going to slow it down for the parent. We want to speak slowly and also clarify. Did the parent understand? And does the parent have any questions? I find that slowing it down helps the parent to understand better, and also helps the parent to participate more. Because sometimes what happens when you speak another language, you get tripped up when it's spoken so quickly, because your mind is not processing in that language so quickly. So you need to slow it down a little bit and then clarify on top of it. I find that's very helpful.
Yes, and I know many of our colleagues would agree that are on this call, whatever, that it's prudent to also ask for all documents that are necessary to make decisions to be translated in your native language before the meeting, and to also make sure that it's not the day before the meeting, but like in a timely manner, like at least a few days to go over it. Would you say, and I know that typically applies in an IEP meeting, but would you say the same is true for this process, or even impartial hearings, certainly, that would be worth asking and making sure that it's being done?
Yes.
This is Patricia, unquestionably.
And I, Joan O'Cray, echo what Pat said. It's important that the parent feels comfortable knowing the information that they're bringing to the table and being able to express themselves in what they want. It's very important that the parent understands that when they come into the room, a lot of times people don't know as much as about their child or their student as they do. So you have to sort of add to the story and bring them up to speed.
There's a question here. Can a parent ask for a translator to be experienced in special education translation? That's a great question.
Yes, I would say yes, yes.
And then you would just make sure to ask that before, or I guess in the intake process would be the point to ask for that, or to ensure that.
Yes.
It should be automatic, right? Some things, so many things I think should be automatic. Let's see. There was a comment from earlier when we were talking about early intervention that our co-director, who's also joining us, Ms. Paula Jordan, that was saying that I think the problem is not really what the parent understands or not about early intervention, but rather not getting the correct explanation about the technical issues related to program eligibility. Parents know that something is not right and that their infant or toddler needs help, and they rely on the evaluations and the initial service coordinator to get this knowledge. Many times, not even the pediatrician is available to just explain this in detail to the parents. Thank you for that comment, Paula. I find that so many professionals that are doing the evaluations also don't know the process. They just know their contribution, and it's pretty much limited right within those parameters. So yes. I have a question here on Facebook, from one of our Facebookers. Good morning, and question about mediation and due process. What is the difference between a resolution session? Oh, I'm so glad this is coming up. What is the difference between a resolution session, which is required part of due process and mediation, and why would a resolution session not be held and the time pass for this? And then they ask if you're interested in mediation. I'm not sure I get the second one, but maybe the panelists got it. I can read it too. But yes, resolution session. What is the difference between that, what is required in due process and mediation? Can someone explain? Sure, Carol.
Okay, so look, an impartial hearing, as a part of an impartial hearing request, there's this discussion that has to take place between, and look, you should check with your lawyers and all this stuff, but sure, there's this discussion that takes place between a parent and the school district to see if they can resolve the matter. It's typically pretty quick, and there's no confidentiality attached to that discussion. If it resolves, though, there's an agreement, and your impartial is done. Mediation is typically a much longer conversation. It's supported by a neutral person. There's a third person, a mediator, well, maybe Joan or Susan or someone on their teams, like Katie, who is there to support the exchange of information and support the conversation. The conversation is kind of slowed down. We know that sometimes people are rushing to get these things done. We can really slow it down, really help people focus on matters. And we can also make sure that the conversation is then confidential, which is really important. Nothing's going to happen in that conversation that's going to go into the hearing unless there's a concern about a serious harm to a child. So, and I would also say that there is a process called mediation in lieu of a resolution session. So a parent, when they're requesting, on that form that the Department of Education has, and you check off, do you want an impartial hearing? You can ask for mediation in lieu of your resolution session. So you can go on that path, but you can ask for a mediator to come in if the matter is resolved. And it's a special education mediation, then the mediator writes it up and your impartial's done. And if it's not, you kind of continue on your way, but you have those legal protections in terms of confidentiality and the slowed down support that the mediator provides. So they sound kind of similar, so I get that, but they're pretty different when they actually are delivered.
Question for you. If a parent isn't satisfied with the mediation results, obviously you can go to impartial hearing, right? But is there anything in between, because the process is so long, so is there somebody can you complain to the state education department or somebody and say can this be reviewed before I ask for an impartial hearing? Does that sort of step exist? Sure, Susan.
We had a case in which we had an agreement from last year when the pandemic all started, and parents were just unhappy with certain things that were going on. I don't know if this is quite it, but they asked for another mediation to just have an addendum to that agreement. And certain things were changed, especially behavior, a little different as perspective, because now the mom is with the child at home, but it's not necessarily, there's certain things that would have to be different. So they had an addendum done to that agreement that they had before. I don't know if that really answers, but that's what we did. And there's also the complaint. If let's say that there's an agreement that was not followed, then they can also file a complaint to the state. And I'm not really sure if that's going to answer, but that's what we had done before, an addendum to an agreement because things changed. And also there's a complaint to the state that they can also file if they feel that that is not being followed as it should.
Okay, so kind of you can request another IEP meeting if something isn't, if some circumstances have changed in the same vein, kind of, right? When you file a complaint, how does that work? Is it just, I'm filing a complaint and an impartial hearing because I didn't get this, so I'm just letting somebody else know basically that this didn't happen correctly, or I think there was something wrong with this? Or is the complaint the request for an impartial hearing?
In this specific case, the parent just had a complaint.
Okay.
That's pretty much it. There was a complaint that, you know, certain things weren't following the agreement. And and then they were just followed after that. But I mean, they didn't have any impartial, I'm sure.
Gotcha. Well, thank you so much. Are there any other questions from our attendees today? We might actually get out a little bit early and give you some more of your day. I know, let me see if I just have any other questions here. Seeing anything.
Patricia, you're muted.
Thank you. I think that it's very important for parents or those who are acting as advocates for students to always have pertinent information, whatever that may mean. Because information, when we sit to talk or discuss an issue, helps everyone who is involved.
Thank you so much, Patricia. Yeah, and you know, we were talking earlier about going into this and trying to be an active participant in the process. We always try to remind parents that you are allowed or entitled to bring somebody with you, you know, to bring a friend, to take notes, to bring somebody else, and to also request a parent member to be present, not to be confused with the role of a parent advocate, of course, but if it certainly makes the parent participation easier, by all means. One question that I did want to ask, and I know the answer, but just to be on record, is that interpretation and translation is at no cost to the families or parents, correct? Correct. I thought so, but it certainly helps to hear it.
Thank you for adding that. That's important. Has no cost to parents. Mediation as well. Let's add that one too while we're at it.
And JC,
Yes.
you can always, if the parent or doesn't feel comfortable with the translator or interpreter, they can always request another. Same thing with mediation. They can always request another mediation, a different mediator.
Okay, that is good to know because I didn't know that.
Yeah, they can. I've had that where someone said, oh, I didn't like the last mediator or whatever. They didn't go over this, they didn't go over that. Then you can request another mediator.
That's
you know,
good.
We're all human, so different people are comfortable with different people.
We do have a question really quick. Can parents contact mediation centers for assistance or questions?
Yes. Yes, they can.
All right, so yeah, so maybe not necessarily requesting a mediation yet, but still kind of exploring the options, or even if they have been through a mediation, like you can always contact them.
Right.
One of the resources that we're going to share with you is the, let me get the acronym correct. It's the, hold on, the Center for Appropriate Dispute Resolution in Special Education, CADRE. And they do a lot of trainings for parents, for mediators, and it's a great resource, a national resource to go to when it comes to learning about mediation process and also impartial hearings. So yes, and we'll be sharing that with you. In the spirit of wrapping things up, just go point by point with each of the centers for any last comments or suggestions and tips that you may have as we go into this second year of second school year during a pandemic. Yes, Susan.
Like we just mentioned before, if they have any questions, I mean, we can answer any procedural question as what can happen here, what happened here, mediation first, impartial hearing, what happens in the mediation. But anything we cannot answer, we have resources. So resources like you, resources like all the other advocates, and like you just mentioned, cadre, and any questions they have, we can guide them at least, we don't have, we are neutral, but we can guide them to the right direction if they need it.
Great. Thank you. Thank you, Susan.
I just wanted to thank you for doing this, JC, and bringing us all together. I love hearing other mediators, so I'm taking this as a learning experience. So thank you, and to do it on a more regular basis would be great.
Yes.
But thank you very much for putting this
Thank
together.
you all for joining. I really appreciate it. It's also just, I was talking to Susan earlier, it's just good to have that face, like, I know that person, or I've seen that person, and I know I can go to that person, especially in this time during this remote everything that we're in or stuck in seemingly, and like, I see their name on a list or on a someone's slide or something. So yeah, it's good to see you all. Yes, Patricia. Were you raising your hand?
No, no, but I've raised my hand a lot, and I'm very grateful for the participants and for those who have been a witness to what we're saying. It is so very important.
Thank you. Joan, please.
Thank you, JC, and thank you all to the panelists that participated and to the participants that are in the audience. Keep in mind, all the centers, you can always call or email or whatever. We're here at the service, and all the mediators collaborate with one another. So I may not have a resource, but if I call Pat, she might have a resource. So it's very important that parents know that we collaborate amongst ourselves as well.
Yes, thank you. Thank you so much. And Carol.
Just want to echo the thanks to you, JC. It was really timely, and I think as we're shifting into the school year, hopefully we can all be supporting the kids, because that's who's important in all these discussions. It's all about the kids. And I'm also delighted to see my colleagues across the city always, but especially now when we can't really see one another. So thanks to all of you, and it's really quite an honor to be among all of you. So thanks for that. But really, parents also, I agree with everything everyone's saying. We're nice people. Ask us questions if you want. We're really very happy to speak with you. Don't feel off put. It's totally fine.
Mm-hmm.
I'll be sharing their contact information, their center's contact information in the follow-up email, as well as a copy of this presentation and a link of to the recording in case you want to share it. Please do. Once we upload it to YouTube, you can activate translation in any language, it seems. So that's really helpful as well. But yes, when you close this screen, you will be invited to take a survey. I'll also activate the poll right now. If you have any questions for Synergia or the parent centers, we're happy to take on your questions, and I'll share my contact info, obviously, as well. But we do have plenty of resources to share with you in the presentation slide, including something from our partners at Advocates for Children that'll guide you on impartial hearings that isn't a part of this presentation today. But thank you so much for everybody being here, and I will follow up with you later. So thank you so much. I'll go ahead and activate that poll now.